Wait, please, Your Lordship.
Hmm.
My Lord, I filed a petition and the filing number is also there. But the matter is very urgent. I pray for listening it tomorrow, my Lord.
What is the urgency involved?
My Lord.
What is the urgency?
Urgency is that some interim protection is required to be obtained. That is why. And in between,
No, no.
there are
What
4
is the
5
urgency
holidays,
there? What interim?
my Lord.
What interim protection for?
Interim protection that a post is lying vacant and the petitioner who is seeking absorption, and if the post is filled up, then the petition will become infructuous. And in between 4 or 5 days holidays are there. That is why.
May it please, Your Lord. May it please, Your Lord.
Teacher, no?
I pray for listing of the petition body in the admission column, Lord, on 16th of March, Lord. It is not inconvenient to the Lord. 16th of March. Deeply
Yeah,
appreciate.
please, Your Lordship. I pray for listing of a matter for orders, Lordship. It's a contempt matter, Lordship. On 10th of March.
May please, Your Lord. Lordship, I
May-
beg-
May I please, Your Lordship? I beg to mention for listing of a motion matter on Monday, my lord, there is a urgency is that, my lord, there is an advertisement issue, my lord.
Which Monday?
9, my lord, on 9, oh, sorry, on 9th, my lord. My lord, on 9th. Deeply obliged, my lord.
May please, Your Lord. Lordship, I beg to mention for listing, Lord, for Monday, Lord, 9th, for 9th, Lord. Yes, Lord. I beg to mention for listing on 9th, Lord.
No, make it 13.
Obliged.
And I beg to mention this matter for listing, my Lord, after vacation, my Lord, any day, my Lord.
15.
All right.
Well, at one motion matter, Lordship, I am praying for listing on 14, Lordship,
14 is the hearing day.
and 15, Lordship. Obliged.
May praise, Your Lordship. I pray for listing of two petitions, Lordship, for admission, Lord, on any day convenient to Your Lordship.
20 March.
This is a contempt petition as well, Lordship, for orders, Lordship, any day.
22nd.
Obliged, Lord.
Item 1 of daily list, motion.
May please, Your Lordship. May
Yes,
please, Your
yes.
Lordship.
Can you hear me now?
May please, Lordship. Lordship, this matter relates to compassionate appointment, Lordship. The father of the petitioner expired in 2015, and thereafter, Lordship, his case was not considered. Petitioner filed an application, pursuant to which Lordship filed 20, Lordship.
Hmm?
Case 20, this is an order dated 18/2/22, issued by District Elementary Education Officer, serial number 2, there is Vibhuti Kaur, addressing the petitioner asked to submit all required documents for
Hmm.
placing in DLC, Lordship. This is issued on 18/2/22. Pursuant to which, Lordship, he submitted all his application. When his case was not considered, then petitioner filed an RTA application, page 21, on 30/7/2022.
Hmm.
Pursuant to his application, Lordship, the additional deputy commissioner on 1 August 2022 informed that I am sending here the Xerox copy of application so and so DLC meeting held on 8/4/22. Lordship, the DLC was furnished to me. Now DLC, Lordship, will find page 22. 8/4/22. Page 22, Lordship. Vibhuti Kaur, decision taken. The proposal of so and so could not be
Serial
considered.
number? Serial number?
Serial number, Lordship, 2, Lordship. It is type copy, Lordship.
Hmm.
Type copy. Case 22. Could not be considered by DLC meeting as his proposal was already rejected in earlier DLC meeting held on 17/11/2015.
Hmm.
Lordship, that was not intimated to me. Now, Lordship, kindly see page 24. The earlier DLC dated 17/11/2015. Page 24, Lordship.
Hmm.
Lordship, is type copy. A minutes of district level committee meeting, so and compassionate appointment held on 17 November 2015, so and so. Now, serial number 10, Office of the District Education Officer, Shivsagar. The proposal received from District Education Officer Shivsagar were 3 different cadres: assistant teacher, LP, and grade 4. I am here, Lordship, assistant teacher, LP. The number of proposals received for the post of assistant teacher for LP schools were 22 in respect of so and so. These are the 22 names, Lordship. Now, Lordship, Lordship, kindly see the fifth line from the bottom, Lordship, the main portion, Lordship. Starting from the proposals, page 24, Lordship. The proposals of so-and-so, 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 Sri Vibhuti, this is petitioner, Lordship, could not be recommended due to lower percentage of marks obtained in ASS degree examination, Lordship. This is the observation. I obtained lower marks in degree, and this is the observation. That is why my case was not considered, Lordship. Now, Lordship, I want to take your Lordship. This is OM of 16 May 2012, page 30, Lordship. Page 30. Petitioner is a graduate, Lordship, BA pass. Page 30, Lordship. Minimum qualification required for appointment as assistant teacher in elementary schools on compassionate ground. These are the, Lordship, NCT norms. Some things are required. Mentioned, Lordship. Now, Lordship, find serial number 3. Cases on or after so and so, so and so. Now, Lordship, for class 1 to 5, A, senior secondary or equivalent at least 50% mark. Here, Lordship, it is admitted true. Petitioner obtained 50 marks in HS examination. But graduate is 50 marks. He is a graduate. But if once he graduate, the HS is not counted, Lordship. This is the OM, Lordship. Now, Lordship, another aspect they have said, Lordship, OM dated 1/6/15. If the vacancies are not available in particular department, this is I have annexed page 31, Lordship. Page 31, a type copy, Lordship. If the sufficient vacancies are not available in particular office, accommodate the person in waiting
Where's
list.
your graduate degree certificate?
Lordship, Lordship, kindly see page 17, Lordship. My mark sheet, Lordship. Page 17.
Yes. This was in 2010.
Yes, Lordship.
When was the DLC considered?
17/11/2015.
Did you submit your graduation?
Yes, Lordship.
Yes, Pukali.
My lord, this case was rejected in the year 2015. And now we are in 2023, my lord. So
But he was informed only in 2022.
again, my lord, he was,
He was not informed.
my lord,
When the second DLC considered his matter, that also he was not informed.
my lord.
When he applied to the RDA only, he came to know. That's all.
My lord, may issue notice. So
Lordship,
You just take instructions and come.
Lordship, otherwise,
What notice you want? Third, Mr.
S.U. Ahmed.
Ahmed, and the council for. Mr. Pukali, and the governor. How much time?
3 weeks.
After 2 weeks, Lordship.
3 weeks.
May I please as your lordship, Lord? May I please as your lordship? My lord, the matter relates to provincialization of these, my lord, petitioners before my lordships. They are, my lord, is now working as an assistant teachers, my lord, in a lower primary schools. Now, my lord, what has happened in the year 2011, although the act was there, but their services for the certain reasons could not be provincialized, my lord. And in the meantime, my lord, they preferred some writ petitions as well as writ appeal before this honorable court. My lord, and accordingly, the 2011 act was also set aside. Now, my lord, for skipping the entire annexures, my lord, what has happened, my lord? The petitioners in the earlier writ petition has filed a writ petition claiming their salary, that we should be paid their salary, and accordingly, my lord, this honorable court at page 100 and page 70, annexure 3, my lord, was pleased to dismiss this writ petition for the reason, my lord, recorded in the order itself, and my lord maybe directly skip the, my lord, few paragraph, the factual part, my lord, and my lord may come to the paragraph, my lord, at page 78, the third paragraph of this page, my lord. My lord has got it, my lord. I am May I read, my lord, the relevant? I am of the considered opinion that an observation of the court in the context of striking down of a statute does not afford a cause of action to the petitioner to launch a fresh litigation to claim salary from the state government when the petitioners were admittedly appointed by the managing committee of the Vansar schools, and it was the managing committee who was paying salary to the petitioner. There was no such direction for payment of salary to the such person whose services were not provincialized under the Act of 2011. And the division bench in the aforesaid judgment had also directed to bring in a fresh legislation expeditiously. Any direction to the state at this moment for payment of salary to the petitioner at par with the other provincialized teachers would, in effect, nullity the order of the division bench passed in the aforesaid case, as in that event, there will be no requirement to bring in any fresh legislation in respect of provincialization of services of the teachers in the Vansar educational institution. Accordingly, my lord, our claim for the payment of salary as our services could not be provincialized, my lord, has been negated by this honorable court. Now, my lord, in the meantime, the government has come up with the new legislation, that is, my lordship is well aware, that 2017 Act, my lord. And in that Act also, my lord, what the provision they have made, my lord, may kindly take up the Act for a moment, my lord. Section 310, 3110 is relevant, my lord. My lord may be pleased to find that provision is at page, my lord. My lord, page is, my lord, is at page 111, my lord. 111 I am referring. My lord may have found it that the two numbers of teachers and oblique or tutors of the Vansar LP school shall be provincialized under this Act, and their services shall be merged with the base school. My lord, the difficulty is that under this Act also, as we are admittedly working as a third assistant teacher, my lord, therefore under the purview of this Act, we are also out. So, my lord, therefore we put into challenge this provision before the division bench of this honorable court. And the division bench of this honorable court has also was pleased to pass an order, my lord. My lord may be pleased to find the order is at starting at page 131, my lord. What has happened, my lord? We preferred a writ appeal against the order which I have just brought into my lordship's kind notice, along with the, my lord, the challenge made to section 3110. And both the cases were taken together and heard together by this honorable court and disposed of by way of a common order, my lord. This order starts at page 122, my lord. My lord may be pleased to find the operative part of the order starts at page 131. May I read over the relevant part, my lord? It has the bearing at page 131, my lord. May I read, my lord? The appellants herein were before the learned single judge in WPC 1689/2017, contending that they were appointed as the assistant teachers in the various lower primary schools under the Botodroba education block in the district of Nagaon, Assam. The claim was that the schools where the petitioners were discharging their duties had been provincialized under the Assam Vansar Educational Institution So-and-so Act of 2011. The claim was that though the petitioners were discharging similar functions as to the other teachers who were employed in the schools and were provincialized under the Act of 2011, not considering the petitioners was not justified. In that regard, it was contended that a coordinate bench of this court, through its judgment and order dated 23/9/2016, which is presently reported at Chandan Kumar Neog and others versus the state of Assam and others, reported in so-and-so, was held that the Act 2011 is unconstitutional. The petitioner herein, in fact, relying on the said judgment, had filed the representation dated 28/10/2016, seeking the release of their salaries for the services rendered by them. The learned single judge, having taken note of the said judgment and also the representation made by the petitioners, had, in that view, arrived at the conclusion that the circumstances wherein the Act 2011 had been struck down and the learned standing counsel for the government had indicated that a new act has been passed by the Assam Legislative Assembly on 10/3/2017, had disposed of the writ petition as having no merits, since any consideration thereafter would arise only under the Assam Education So-and-so Organization Act of 2017. Presently, at the point of consideration of the appeal, the Act 2017 is in force, and in that light, a consideration is required to be made herein. The learned counsel for the appellants would, in that light, contended that this court, while striking down the Act 2011 in the case of so-and-so and others, had arrived at the conclusion that the provincialization of the teachers limited to the number of teachers without reference to the number of students under this act is not justified, in as much as the same would run contrary to the provision of the Right to Education Act. In that light, it was observed that the RTE Act provides that the teachers appointed should be proportionate to the students available in the institution. In that light, the learned counsel contended that the petitioners are continuing to discharge their duties, which would indicate that their services are required by the institution, yet they are not being paid their salary, and in the light the representation had been made seeking for the release of the salary. It is also her contention that even if an order of provincializing the services of the petitioner was not passed by the respondents, the same cannot deny the benefit of the salary to the petitioners, and therefore an appropriate direction is required to be issued. The learned standing counsel would, however, contend that at the outset, what is necessary to be taken note is to whether the claim as being put forth by the appellants that they are appointed in the said institutions and are discharging their duties are the factual aspects which is to be determined by the respondents. It is only contended by him that when the Act 2017 is presently in force, all rights claimed by only arise under the said Act only on examination of all aspects. A decision could be taken by the respondents to arrive at a conclusion as to whether the appellants oblique petitioners are entitled to provincialization or not, and whether they are actually discharging their duties. According to the learned standing counsel, the liability of the government would arise only after the provincialization is made, and in respect of the staff who have been provincialized under such order. He therefore contended that the prayer as made by the appellants would not be justified. Having taken note of these facts, we have at the outset carefully perused the judgment in the case of the Chandan Kumar Neog and others supra, wherein the observation was made by this court with regard to the teacher-student ratio as one of the aspects to take note the Act of 2011 cannot be sustained. After the 2011 Act has been struck down, though the judgment, the undisputed fact is that the Act 2017 has been passed. It is in that view of the connected petition, Section 8 of the said Act has been assailed. At the outset, what is necessary to be taken note is that the appellants will have to establish their claim for provincialization of their services if the institutions wherein the claim to work have been provincialized. In this regard, the decision by the competent authority is to be taken with regard to the provincialization of the institutions under the Act of 2017, and in the said process, the number of teachers of staff to be provincialized as per the provision as contended herein. At present, there is no material on record to indicate that the services of the appellants has been provincialized or order provincializing the institution where they claim to work is on record. Therefore, at this juncture, though the appellants have sought to rely on the service certificates of the year 2016-17 said to be issued by the various institutions, the correctness of the same cannot be decided in this writ petition. So, my lord, the entire thing has been recorded there. My lord, may be pleased to skip the few parts.
Kindly see page 135, my lord.
My lord, I have not finished, my lord. I have not finished. I am coming to that also, my lord. Now, my lord, this has been faked, and my lord may skip the few parts. Therefore, the appropriate course, I am reading from the middle part, my lord, from therefore, my lord, at page 134, my lord.
Yeah.
Therefore, the appropriate course would be to permit the appellants to make appropriate representation application to the respondent number 1, namely Commissioner and Secretary to the Government of Assam Education Elementary Department enclosing materials along with the such representations to indicate that the appellants have been discharging their duties in the institutions, and also produce the such materials to claim provincialization of their services. If such representation is made, the respondent number 1 may either seek for further materials from the appellants in support of their claim, or secure such materials from the concerned institution and examine the representation in accordance with law. On such examination, if the respondent number one considers that the appellants are entitled to the provincialization of their services, an appropriate order in that regard be made thereafter. However, if on examination, the respondent number one is of the opinion that if the institution wherein the appellant's claims to work is provincialized, the services of the appellant is not entitled to be provincialized, the reason for the same be intimated to the appellants. If the claim of provincialization by the appellants is rejected, and in that circumstances, if the appellant seek for payment of salaries from the other either of the authorities, namely the government or the erstwhile management, a consideration in that regard will be subject to availability of the appropriate materials, and the same is left open to in accordance with law. In view of the above conclusion in the writ appeal, and since on today there is no material on record to indicate provincialization of the services of the appellant, the prayer made in so and so of the Act of 2000 is premature at this stage, and the prayer therein does not arise for consideration. In terms of the above, with liberty reserved to the appellants to make such representation, the appeal also, the writ petition stands disposed of. Now, my lord, this summary is very simple, my lord, that we are required to make a representation that how we are entitled to be provincialized, and the authorities are required to make a consideration. Accordingly, my lord, responding to the same, we made a representation, my lord, at page 136, my lord. And narrating the entire facts, my lord may kindly note the date. It is of 8/4/2019, my lord. Although, my lord, no receipt and acknowledgement had been given to this representation, my lord. And after this representation, the authorities acted only on, my lord, 21/12/2022. My lord, kindly peruse page number 139, my lord. This is the letter, my lord, which has been communicated by the District Elementary Education Officer addressed to the Director of Elementary Education, Assam, my lord, wherein the entire facts regarding our status at present of the school has been, my lord, narrated. Now, my lord, the authorities, as per the order of this Honorable Division Bench, order of this Honorable Court, is required to, my lord, make a consideration of the direction which has been given. So, my lord, my very limited prayer, my lord, is that the representation which we have made may be disposed of in terms of the order passed by the Division Bench of this Honorable Court. That much, my lord, prayer I have made, my lord, in this petition.
My lord, lordship may dispose of the matter directing the authority to
Yes.
dispose of their.
Have you received the representation?
My lord,
If not, my lord, we will make a fresh again, my lord.
my lord, no need, my lord, let them file this copy of the writ petition along with the order of
Yes,
this honorable court, my lord.
But Mr. Bhuya. Also heard Mr.
I am for 1 to 4, my lord. Respondent number 1 to 4, my lord.
Senate Council for the responding, standing council.
Elementary Education Department.
Elementary for the responding. For
5, I may appear.
Mr. P. Nayak.
Not
Senate
respondent
Council
5.
Finance for 5. So, the petitioners are all appointed. Were appointed as assistant teacher in different schools of Nagaon district.
Bottodrava Education Block in the district of Nagaon, my lord. I have stated, I'll submit the copy of the petition, my lord. It is entire fact is there in paragraph 2. I have narrated our, my lord, appointment and continuous working.
In the, which block is it? Which block?
My lord, Bottodrava Education Block in the district of Nagaon. My lord, may record the paragraph 2, wherein, my lord, I have narrated the entire facts, wherein the petitioner is now working.
Under Batatrava block
My lord,
in the district of Nagaon.
my lord.
Nagaon. And rendering the service as third and fourth
Third and fourth assistant teachers.
assistant teacher in their respective schools. of all the schools in which the petitioners are presently employed are working were provincialized
In the year 2011, my lord.
in the year 2000. In the meantime, the Assam Venture Educational Institution within bracket provincialization of the Act 2011 was
Shut down.
struck down by a division bench of this court in the case of
Chandan Kumar
Chandan
Neo.
Kumar Niyok and others for the state of Assam. Reported in 2016 within bracket 5 GLP 296 as unconstitutional. The petitioner draft filed a representation filed a writ petition
My lord, claiming salary, my lord.
being with WBC number
My lord,
6861
my lord,
of 2014. No, not, uh,
my lord, WPC 1689 of
Page-
2017, page 70, my lord,
169
89.
of 2014. Praying for
Salary, my lord.
salary at par with
Ma-
the provincialized
Yes,
teacher.
my lord.
How, by order dated 19/4/2020,
17.
the said petition was dismissed. On the ground that
Page 78, last paragraph.
was dismissed. The petitioners again filed the petitioner drafter filed an appeal against the order dated 19/4/2007,
My lord,
passed in WPC 1689 of 2017, which was registered as writ appeal 293 of 2007,
17.
and also filed a writ petition being WBC 6703 of 2017, challenging the violence of
My lord.
section
Section 8,
8 within bracket 2
my lord.
of the Act of the
2017, my lord, the Assam
Assam Educational
reorganization of. My lord.
Provincialization of teachers and reorganization of educational institutions
My lord.
Act 2007. Section 8(2). Usually section 8(2).
My lord.
Yes.
My lord.
Both the writ appeals 293 of 2007 and WBC 6703 of 2017 were heard together by a division bench of this court and was disposed of by an order dated 5/3/2019,
My lord.
giving liberty to the petitioner to file representation. Correct?
Yes, my lord. Yes, my lord. Paragraph page 134, therefore it starts, my lord.
to make representation before the appropriate authority, including materials along with the representation to indicate that the applicants have been discharging the duties in the institution. So, how WBC number 6703 of 2017 was disposed of as being premature.
Mal.
But in terms of the order dated 5/3/2019, passed in with appeal number
293.
2
Writ appeal number 293 of 2007.
293 of 2017 and WBC 6703 of 2000. Petitioners matter represented on
Lord, which is on 8/4/2009.
before the Commissioner and Secretary, Government of Assam, Education within bracket Elementary Department, praying for provincialization of its
Mal.
services and release of talent. The said representation. It has not been disposed till
No, my lord, but the district elementary has, my lord, reported the entire facts by his letter dated 21/12/22 at page 139, my lord. That can kindly be recorded.
This is an interdepartmental communication. Mal. This is an interdepartmental communication. Mal.
yes, this is purely in the department, not required. The said representation is yet to be considered
Mal.
by the concerned authority. Till then. Accordingly, from district directing the petitioner to file a fresh representation, enclosing a copy of this
Writ petition also.
along with the annexures printed
Mal.
before the
Commissioner, my lord, secretary, my lord.
Commissioner and Secretary, before the Secretary
Yes, ma'am.
to the Government of Assam,
Full education.
School Education Department, correct?
Yes, my lord.
School Education Department. Within a period of
10 days from today, my
10
lord.
days to the effect of
No, dispose.
thereafter come the Secretary to also Secretary to the Government of Assam. With the oblique response number 1. Thereafter, response number 1 shall consider and dispose of the by on
Mal.
and in accordance with law. Within a period of
2 months.
2 months from the date of
Mal. If not dispose of their representation dated
uh,
4/8/4/2019.
of the if the I don't think you have
That has not been
If
taken
dispose,
into
my
account.
lordship may
That's
direct
not
authorities, if dispose this, the representation 8/4/2019, let them communicate it to the petitioner, my lord. If
It has
dispose,
not been disposed of, my lord, as per our instruction.
with effect from the date of receipt of the if the representation dated
8/4/2019, my lord.
8/4/2019 has already been
Mal.
then the outcome of such consideration shall also be to the court
My lord.
with the above.
Highly obliged.
Obliged, my lord.
Nineteen of supplementary list. Motion. Nineteen.
May I please, your lordship? My senior on legs, your lordship, for timing, your lordship.
Is a contempt.
Brief is with my senior, your lordship. Just 5 minutes, your lordship, for time.
Who's your senior?
PK Dekha, your lordship.
But Mr. PK Tekal, let's counsel for. Issue not. Petitioner to take steps for purpose of public on the topic. Please conduct a
Oblige, your lordship.
Free of daily list, the vacating application.
Wait, please, your lordship.
Can you hear me?
May I please, lordship?
Lordship,
This requisition has been filed, my lord, challenging the appointment of respondent number 8, my lord, who
Who
is
is this IA?
yes, IA, actually IA have been filed by the respondent lordship. The respondent number 8. Trying for vacating the interim order whereby his benefit of provincialization has been stayed. And so this case has come up today, and along with this case, the main case. Lordship, the petitioner had challenged my appointment on the count that he is senior to me, she is senior to me. So here the issue is that whether she being a claiming to be a teacher in language Assamese can claim seniority over me while I am serving as a Hindi teacher, lordship, a specific post of Hindi teacher. So that is the issue, lordship. She is admittedly senior as per the date of appointment, lordship, but her appointment was against a sectional post, lordship. Sectional
Let
post.
us hear your.
Yes,
case.
yes, my lord.
Let us hear the.
My lord. My lord, petitioner has been appointed by resolution dated, my lord, 26/8/2003, that is, my lord, page 22, my lord, kindly see page 22, and exact 3, my lord.
No, you are against the recommendation of the private respondent.
My lord, since I am senior, my lord, I am teaching in the subject of Assamese, my lord.
You have been already provincialized.
Yes, my lord.
I've been provincialized.
I am senior teacher, my lord. Assamese, Arabic, and Hindi teacher are treated as a language teacher as per Act of 17, my lord. So, my lord, admittedly, my service ought to have been provincialized, my lord, before provincialization of the service of respondent number 8. Respondent number 8 appointed, my lord, in the year 2009. While
DLC recommended your case.
no, my lord, my case has not been recommended, my lord. So, my lord, at that time, my lord, at the time of filing of my petition, my lord, I was unaware, my lord, regarding the recommendation of DLC, my lord. Subsequently, while my lord, my friend filed miscase, my lord, for vacating the order, my lord, then, my lord, we have come to know that our case has not been recommended by the DLC. My lord, at this stage, my lord, may I say, my lord, may I file appeal, my lord, before the director, my lord, as per section 14, my lord.
SLC has already met this
Yes,
recommendation.
lordship. I have been appointed, I got
He recommended his case, my lord.
his salaries also, and the benefits has been stayed,
Given to
lordship.
you.
Yes, lordship. My benefits subsequently
Then,
stayed lordship, after provincialization as tutor, lordship.
You'll have to approach the state government,
My lord, so, my lord,
not the director.
Yes,
Director is the chairman of the SLC.
yes, my lord. So, my lord, I may be allowed to file an appeal, my lord, as per section 14, my lord. Until then, my lord, interim order
No,
may
lordship.
continue, my lord.
No, lordship,
This
I
is
have
my,
objection.
my lord, Humble prayer before you. Otherwise, my lord, all my lord purpose will be infrastructure, my lord.
Lordship,
Third, Mr.
A. Hussain.
A. Hussain, Learned Counsel for the petition.
may I submit, Lordship?
In the writ petition.
Lordship.
Yeah.
Lordship, my submission is that the prayer of the petitioner may be allowed, Lordship. The matter may be sent to the state level committee. I have no objection, Lordship. But the stay order may be vacated.
State level committee has already.
Yes, Lordship, the state authority, Lordship. I am the state government. So he may be directed to approach the state government.
Will give the state government
Lordship,
a specific period of time.
Lordship.
Till then, the stay will continue.
Yes, my lord.
That's all.
Yes. my lord.
Mr. A. Hussain, Learned Counsel for the petitioner. Also heard Mr.
Jadise,
Z.
Hussain.
Hussain. Learned. Who appears for the?
I am appearing for elementary education, my lord. One,
Mr. H. Bora, Learned Standing Counsel, Elementary Education, appears for respondents.
1, 2, 3, 5 and 6, ma'am.
3, 5 and 6. MS GD Barman, Learned Government Advocate for respond number 4. And Mr. Z. Hussain,
Jadise, Lordship.
Learned Counsel
8.
for respond number 8.
Lordship.
By this writ petition, the petitioner is challenging the provincialization order of the respond number 7 and 8.
8, my
Eight,
lord. Yes.
Only 8.
Challenge only 8, Lordship.
Who's 7?
7 is headmaster, my lord.
Well, the
Yes.
provincialization of the service of the respond number 8. As where's the provincialization order?
Yes, my lord. I have enough.
There is a page 41, 41 of this writ petition.
As tutor, signed.
Yes, my lord.
Signed.
Hindi, Lordship.
Where's Hindi?
There is no mention, my lord. Only tutor, my lord.
As tutor.
Yes.
Just tutor, but I am Hindi teacher, Lordship.
In the which school?
My lord, Colony Jala Navarashmi ME Madrasa.
In the Kalani Jala Navarashmi ME Madrasa. On the ground that he is senior to the petitioner, correct?
My lord, yes, I am senior, my lord.
And therefore, the petitioner should have been provincialized instead of the respond number 8. Stop. At this stage, Learned Counsel for petitioner prays for filing an appeal under section 14 of the so-and-so Act of 2017. Act of 2017. Para. Recording the submission made by the Learned Counsel for the petition. This writ petition is disposed of. Directing the petitioner to file an appeal before the to file an appeal under section 14 of the Act of 2017 before the government. Will be the state government. Before the state government in the concerned department. Within a period of
10 days, my lord.
within a period of 2 weeks. from
Yes.
today. Thereafter, comma, the appellate authority on receipt of the appeal shall afford an opportunity of hearing to the petitioner as well as the respond number 8
Lordship.
and thereafter, and dispose of the appeal in accordance with law within a period of
3 months, my lord.
3 months.
2 months, Lordship. Already I am suffering a lot, Lordship.
They have to hear, my lord, my lord.
2025.
Petitioner has
2
to
months, you
hear.
can do it within a
2
period
months,
of
Lordship.
2 months from the date of the appeal. Till the appeal is disposed of by the appellate, interim order passed by this court shall continue to operate. With the appellate of conviction from that strict petition is disposed of. In the IA, in view of the order passed in the amendment, IS disposed.
Oblige, my lord.
4. May I please, as your lordship? Lord, my respected friend is required to obtain an instruction, my lord. Now, what is his instruction? I am not aware, my lord.
Yes.
কি বস্তু এটা?
What is this?
On earlier occasion, I have provided a copy of the order notification dated 21/1. A notification dated 21/1, 2023, my lord. In that notification, my lord,
1 minute.
Lord, what has happened, as I have understood, my lord, the order of transfer, which I put into challenge before this honorable court, had been stayed by this honorable court by way of an interim order. My lord, in compliance with that interim order, my lord, they have reverted back this private respondent in his original place. Now, my lord, in that reversion order, they have mentioned it as a, my lord, pursuant to the honorable high court's order dated. Now, as from this order, my lord, I have understood that the in place of the pursuance of honorable high court order, it has been replaced as, my lord, in the interest of public service, my lord. So therefore, my lord, it is a one kind of revocation or cancellation of the impugned order which I am challenging in my petition, my lord.
Yes.
Now, my lord, the very basis of my writ petition challenging, my lord, is no more in view of this, my lord, order passed. Now, if the private respondent is agreed, my lord, then he is required to challenge these orders, my lord. That's the situation, my lord.
Lord,
Doctor?
the stand of the state government, my lord. Initially, they passed an order saying that.
I
because
know, I know.
It's
No, basically the
difficult to understand, my lord. Interim order passed.
grievance of the petitioner.
During the pendency of the repetition, that stand, my lord, very will be stand. Initially, they passed the order, the state respondent.
So you'll have to challenge this order.
That's true, my lord. And I'm retiring in October. So they again put me in the same place. So there is no sanctity in the decision making process.
Unfortunately, court cannot say anything today.
I understand, my lord. It appears that there is no rationality in the decision making process. In one fine morning, you say that in the interest of public service, you are
You go and join there,
sorry.
and then when the writ petition is filed, they revoke your order.
I cannot stop the
Lord, they have,
petitioner from
they have
withdrawing the
real,
petition.
my lord, my understanding is that, my lord, they have realized that it is not a order passed in accordance with law. So that's why, my lord, they, in the interest of public service, again reverted back. They have realized their fault.
So you want to withdraw?
Or my lord may observe this and close my petition, my lord, and with a liberty, my lord, if in future, if cause of action arises, my lord may, because my lord, I will be also helpless, my lord, if something happens, my lord may record this development and can close my petition, my lord.
Yes, I think you'll have to file a writ.
My lord, my lord. Remedy is available to them, my lord. They can
Let
challenge.
Mr. Abuyan learn sponsor for petitioner. Also heard Mr.
Huh?
Who's appearing?
well, I am appearing for Elementary Education Department, my lord.
Learned standing counsel. elementary education correspondence, 1, 2,
One and two, my lord.
1 and 2.
For
Mr.
three. I have been for three.
Mr.
That's what.
S. Bora, Learned Standing Council,
That's it.
State Council of, no, appears for the response number 3. And 4, MS P. Report it. Learned Standing Council, Assam Public Service Committee for response number 4. D.D. Barman, Learned Government Expert for response number 5. Mr. M. Datta, Learned Council for response number. You are Jibindu Datta, isn't it?
Jibendu Datta, my B Purakash to appear, my lord.
My friend.
B. Purka, for response number 6.
That's number 7, my lord.
B. Purka, council for response number 6. So, Magistrate petition. The petitioner is challenging
Order at page 128.
order dated 22nd December 2022. Issued by the Secretary to the Government of Assam, Department of School Education, by which the respondent number 6,
Six.
correct,
Yes, my lord, 6.
correct, was transferred and posted as
Principal, my lord.
principal diet Hailakandi,
My lord.
and the response number 7. Senior lecturer of Diet Pacha was allowed to take over the charge of in charge principal of Diet Pacha from the response number.
My lord.
During the pendency of this. No. Don't connect. Mr. S.K. Bora, Learned Standing Council Elementary Education,
My lord.
has produced an order, notification dated 21/1/2003, by which the impugned order has been revoked, isn't it?
My lord.
My lord.
The same reads as under A to A. So, he has also produced another corrigendum dated 1st March 2023, which also reads as under B to B. Considering the notification dated 21/1/2023 and corrigendum dated 1st March 2023, the very best for filing the writ petition has been removed,
My lord.
and according, I see no reason in proceeding with the present petition. Accordingly, writ petition is closed with liberty to the petitioner to file after if so advised.
My lord.
in future.
Some liberty to me if I have any.
Required, my lord, they can at
That
any
is-
time.
You have the full liberty, it is not. Writ
Only
petition
one
is
prayer,
referred
my
to
lord.
is post of.
Only one prayer. If because I am the sufferer of when this entire process, writ petition as well as the stand of the government. But if I file a representation, if that can be considered, that much only.
No, you can file your own representation. Here it is writ petition.
My lord.
So I find it difficult to pass any order.
I understand.
In view of the order passing the main writ, I also stop. The order dated, notification dated 21/1/2003 and the corrigendum dated 1st March 2023 is placed on the file.
Obliged, highly obliged.
Deeply.
5, 6, and 7. Part of admission method.
My lord, these three petitions relate to the same grievance that the petitioners are contractual teachers, and in an advertisement for fresh recruitment, marks for experiences teacher was not provided in the advertisement, and that is the grievance in item number 5 and 6. And in item number 7, this non-providing of marks for experience as well as relaxation of age is sought. So your lordships have heard me for the petitioners. Now the state wants to make.
My lord, actually, I missed the file, my lord. It is in my office and today I did not get it. Either at 2, my lord, or
No, not to.
let it be on some other day, my lord. I left it at my chamber, my lord.
The parted matter,
It's not part heard.
Part heard.
Part heard.
then will have to be taken up after I come back.
To my lord, yes. By mistake, I left it. Just now I'm informed that it is with me.
मिठुन में लगा ना मिठुन में लगा के but Mr.
Olas.
Learner Council for the and requested by our Madhya Standing Council, School Education Department.
My lord.
Please the matter for further hearing on 28 March,
My lord,
28 of as part.
Lordship, I am appearing for SSL lot.
Mr. Nayak, April 48.
I'm also appearing for SSL.
And Mr. I Alam, Learned Council, R Alam or I Alam?
I am
Learned Standing Council,
for NCT, my lord.
also appears for the NCT.
20 of supplementary list, admission to part third matter.
my lord, date,
28.
no, but date may be fixed. This is part heard matter.
I said, that's why I said 28,
20,
yeah, of
My-
March.
my lord, 20.
20,
28 March.
Obliged.
Already in item number 20, our part has already been done, my lord.
Just the reply has.
Yes. Senior Advocate, Mr.
No, council is not present.
No, my lord, I haven't seen. Or maybe fix it in another day, my lord.
None appears for the petition. Mr.
Yes, that's my lord.
There's dust and the
Higher
Standing
education.
Council. I appears for the higher. It's the matter again on 21st March.
Much lord.
8 of daily list,
Please, Your Lordship. This can be taken up for disposal. In fact,
Can be taken after some time.
Sometime, my lord.
AG is electing court number 1.
Huh?
AG is electing court number, it can be taken after some time, my lord. You'll be coming, my lord.
9,
My lord, on
Please, your lordship.
the
Close of the
last order, my lord had required the Dibrugarh University to produce the records of the selection process.
Yes,
Now, my lord, this selection process is held by the governing body of the college, where the president is the secretary of the selection committee. It has to come from the governing body, my lord, not from the Dibrugarh University. So therefore, my lord, the records would be produced by my
By
lord,
whom?
the respondent number 5.
Who appears for
But
5?
I am appearing for respondent number 5, Lordship. Affidavit is ready in a day or two, I will file, Lordship. Regarding records, Lordship,
You produce the report in
Lordship.
original.
Lordship.
4 and 5, your lordship, maybe.
Four no.
Not 4.
I am just the chairman. But Mr.
DJ Das, your lordship.
DJ Das,
Lordship, my only anxiety is that matter has been pending for 1.5 years,
I
lordship.
know.
That it will get infructuous, lordship. The short date may be given, lordship.
For the post of principal.
Hmm.
DJ Learning Council for. Also had Mr. R. Majumdar, then standing council.
Dibrugarh University, my lord, I'm appearing for number 4.
Dibrugarh University.
I'm for respond number 6, madam.
Mr. TJ Mandal and.
Respond number six.
Respond number 6. And
For respond number 3. I'm Dr. for respondent number 3.
M. Datta, then council for respond number 3. S. Das, then standing council. Higher education for respondent 1 and 2. MS RDV, RA.
Yes,
RDV, then council for respond number.
5.
5 submits that the affidavit is ready and shall be filing the same within 2 days.
Hmm.
List the matter again on, you want a short date?
A short date, lordship. Maybe on a hearing day, lordship. Just like today, lord.
On a hearing day.
Equal.
How about 14th or 16th?
Lordship, 14 is better, lordship. 16, lordship, my senior will have some difficulty. 14, lordship.
List the matter again on 14th of March. 2022. On the next, by the next suitable date. MSR Devil and council for respond number 5
5.
shall also produce the report in order.
Much obliged, lord.
Obliged.
I'm obliged.
10.
My lord, in this case, I am led by senior counsel, Mr. UK Nair, who is on legs in court number 1. Can this matter be passed over for a time being?
Okay, we'll see.
11.
My lord.
My lord.
In view of the appellate provision, my lord.
The court, my lord, kindly pass over the matter for time being.
Why?
My lord, he is engaged in another court.
There is a appellate provision, my lord. Let them go to tribunal, my lord. As your lordship has already been disposed of so many cases.
Hey, to need open.
They are seeking provincialization, my lord.
Of the service.
Yes, as a grade 4, but in our affidavit, lordship, we have specifically stated that there is no provision for provisions of grade 4 lordships in library bearer. As per the 2018 Act, in our affidavit, it is clear, lord. I'm sorry, my lord.
Yeah.
My lord, my lord, matter particularly non-provincialization of service of the petitioner, my lord. My lord, petitioner is appointed as a grade 4 employee. my lord.
PLC recommended your matter.
Yes, my lord.
SLC turned it down.
Yes, my lord.
Then you file an appeal. Go to the state of.
My lord, see the service of the respondent number 5 has already been provincialized, my lord.
That's why.
That's why, lord.
File an appeal. Any interim order is there?
No, my lord, not true. My
What
lord,
is your case? What is your case? You are claiming seniority of the respondent, isn't it? Respond number 5.
yes, yes, my lord. My lord, after 2011 Act, my lord, while the name was forwarded, my lord, he was never in the place, my lord. Subsequently, after enactment of the 2017 Act, my lord, his name was shown as excess employee, my lord. But director, my lord, I don't know, my lord, how, my lord, in violation of the, my lord, district
DLC
report, my lord. My lord, kindly see, my lord. Page 18, my lord, is the, my lord, report of the district scrutiny committee, my lord. And page 19, my lord, kindly see, non-teaching staff, my lord. my lord, my name is there, my lord, MD Pierre Ali. And
Where,
there
where?
is no five, Imran Hussain has shown as access employment. But director, my lord, I don't know, my lord, how director my lord, can, in violation of the, my lord, district school committee report, my lord.
No, where's the recommendation of the TLC? This is the recommendation.
Yes, yes, my lord.
Page 20. Format for a report of district scrutiny committee.
Type copy. I am reading from type copy, my lord.
Is this a recommendation?
Yes, my lord. Format for report of district school committee, my lord. That was, my lord, the page 21, my lord. These are the district school committee, my lord. They are recommended, my lord.
Then SLC?
And the SLC report is not there, my lord. My lord, it was forwarded to the, my lord, director of elementary, secondary education, my lord.
Where's the provincialization order?
My lord.
Where's the order of provincialization?
My lord, page 24, my lord. And page 25, my lord, here the respondent of 5's name is there at serial number 17, my lord.
Does it come under section 14?
14, yes, lordships. Yes, lord.
Then you file your appeal
Before the commissioner, my lord.
before the government.
Yeah.
Third, Mr.
Yes, my lord.
S. Haq, Learner Council for the petition. Also heard Mr. SMP PhD, then the Standing Council.
1, 2, 3. 1, 2, and 3.
Secondary education correspondence on to
1, 2, and 3.
and Mr. Your good name
R. Ali, my lord.
R. Ali, Learner
For
Council
respondent of 5.
for the respondent. Petitioner was appointed as a library bearer at the Brahmaputra Valley Senior Secondary School, Kanara, Barbita, on 19/12/2006. To which post he joined on 1/1/2007. Stop. The respondent number 5 was appointed on 8/10/2007 as
Grade
Grade
4,
4, my lord.
grade 4.
as a grade 4 employee. The district level committee recommended the case of the petitioner as well as the respondent number 5 for provincialization of the services in the said school. While making the recommendation with regard to respondent number 5, his status as is shown as within inverted commas excess engagement. However, the state level scrutiny committee provincialized the service, recommended the case of the respondent number 5. And the case of the petitioner was dropped. The respondent number 5 was according. Service of the petitioner was accordingly provincialized by order dated 4th February 2022 as
Grade 4, my lord.
grade 4 employee. In which school? No school is named. Stop. In
Brahmaputra Valley
Brahmaputra Valley Senior Secondary School, District.
Barbita.
Will take from 1st January 2022. Stop. Being aggrieved, petitioners reported for. Being aggrieved with the provincialization of the service of respondent number 5.
No, my lord, he did not
Petitioner-
sell us my promotion appointment. He is seeking provincialization.
That's why petitioner is reported for. Section 14 of the Act of 2007, of the Act of, Section 14 of Act within bracket 2000 Act of 2017. appeal before the state government on the recommendation of the state level scrutiny committee. According to petition is direct filed in appeal. Under Section 14 of the Act of 2017 before the state government of the appellate authority within a period of
My lord, 1 week, 1 week.
1 week from draft on receipt of the appeal. The appellate authority shall hear the petitioner, but shall hear the petitioner as well as respond number 5
Right.
in person and thereafter dispose of the appeal by executing order and in accordance with law within a period of 2 months.
2 months.
2 months from the date of with the observation in that.
Right.
Oblige your.
Obligement.
8.
The petitioners are the officers of the District Institute of Education and Training, the association, the institute, the body which has been formed to cater to the preparation of training of teachers. Basically, they cater to that. And their grievance in the writ petition pertains to non-granting of the restructuring benefit of the centrally sponsored teachers scheme upon the diet, whereas the state government has granted those benefits to the SCRT, that is the State Council of Education, Research and Training. Whereas these forms two different limbs of the centrally sponsored teacher education scheme. And the restructuring of the scheme that has been evolving since the past almost 2 decades, and the Diet Association, as the benefits had been granted to the SCRT organization, they have been ventilating their grievances before the government in the elementary education department, under which whose jurisdiction the Diet comes. That these, as part of the scheme, that is a centrally sponsored scheme, the guidelines evolved by the MHRD. The benefits, the restructuring benefits has to be given to the Diet officers also, not merely on the SCRT officers. And as it is the representations, etc., these were not disposed of, we approached the Honorable Court. And the Honorable Court issued it after perusing the materials on record, was of the view that the matter needs examination on the, and prima facie it appears that the restructuring benefits has to be given to the Diet officers also. And before the finalization of the restructuring scheme of the SCRT, this has to done. Lordship, I'll take your Lordship to the that order at page 76. Order dated 9/12/2019, passed in WPC 9056 of 2019. The operative portions I'll read out. This is Lordship 76 from page 77. I just read out these few paragraphs. Second paragraphs onwards. It has been submitted that pursuant to the, I'll start with the paragraph number 3 onwards. The grievance of the petitioner relates to negligence on the part of the respondent authorities in restructuring the District Institute of Education and Training in Assam. Necessary restructuring has been done in respect of State Council of Education, Research and Training. In terms of the recommendation made by the Ministry of Human Resource Development for restructuring and strengthening the SCRT as well as the Diet in the state, in terms of the report made in 2009, as well as the guidelines for implementing such recommendations issued in 2012. It has been submitted that pursuant to the said report and guidelines issued, the SCRT has been reorganized and restructured by creating additional posts which have been financed with the funding arrangement of 90:10 by the center and state respectively. However, similar restructuring and strengthening process in respect of Diet, which had also been recommended by the same report, had not been undertaken, and accordingly, being aggrieved, the petitioner had submitted a representation before the respondent authorities. It has been submitted that the state government has been representing to the competent authorities about certain steps like creating of common cadre of teacher educators, which is meant for both the SCRT and DIET, have already been completed by creating a separate cadre. Thus, it seems that the authorities had proceeded in restructuring, but without any changes in DIET, while restructuring reorganization only in respect of SCRT. It has been submitted that as per the guidelines issued by the MHRD in 2012, the central funding is to be routed directly through the state education secretaries, then to the SCRTs for onward disbursement to Institute of Advanced Studies in Education, College of Teacher Education and DIETs, and the state budget heads are put factor in state share and the central assistance. It has been submitted that since the central funds are routed through these SCRT, there is a possibility that appropriate funds may not be made available for restructuring and strengthening of the DIET in terms of the aforesaid policy framed by the MHRD, but made applicable only for SCRT. The court is of the view that this is a matter which would require proper application of mind by the authorities, as the guidelines contemplate restructuring of DIET also, and not only the SCRT. Accordingly, the authorities will consider representation so submitted by the petitioner for restructuring and strengthening of DIET, so that the benefit which has been already conferred on the SCRT can also be extended to the DIET. This is the observation of the Honorable Court. Accordingly, the present petition is disposed of, directing the respondent authorities to consider the representation dated so-and-so submitted by the petitioner as expeditiously as possible, preferably within a period of 4 months and at least before finalizing the restructure of the SCRT, so that restructuring and reorganization of both the DIET and the SCRT can be completed at the same time, and both can have similar benefit from the date of receipt of a certified. Now, after pursuant to the order, the a speaking order has been issued in compliance of this order by the Commissioner and Secretary Elementary Education Department at page 79. Now, even though we are challenging this order because we are aggrieved by part of that order, but in fact, there is what has been stated in this, in compliance of this order, they have undertaken certain steps. That order, that speaking order dated 18 May 2020, paragraph 3, if your lordship peruses, paragraph 3. Though the paragraphs are not numbered, but there is a column there, the third paragraph. The order, has your lordship got it? Order dated 19/12/2019, passed by the Honorable Guwahati High Court in WPC number so-and-so, which was disposed of with a direction that the respondent authorities to consider the representation dated 7/1/2018 as expeditiously as possible, preferably within 4 months, and at least before finalizing the restructuring of SCRT, so that restructuring and reorganization of both the DIETs and SCRT can be completed at the same time, and both can have similar benefits. Therefore, the government of Assam in Elementary Education Department has already processed 3 files. Number one, number so-and-so since June 2014. Matter relating to common cadre of SCRT and TEIs. TEIs means the Teacher Education Institutes. These comprise of the College of Teacher Education, the IASCs, Institute of Advanced Studies, the DIETs, all these comprise of the Teacher Education Institutes. Next is AE number so-and-so since January 2019. Matter relating to upgradation of post. Third file since January 2019, matter relating to redesignation of post. And these files have been sent to various concerned departments for their views and NOCs. Views of several departments have been received and views of other departments are awaited at this. And now, if I may pause here for a moment. These 3 files we are concerned with, the government has, the Commissioner and Secretary, while issuing this order, it has clearly been stated in compliance of that order, these files have been moved. These files have been processed. The first relates to creation of a common cadre of teacher educators of SCRT and TEIs. This is the relief which we want under that restructuring program. This is the basic relief which we want. That creation of a common cadre of teacher educators. These teacher educators will comprise of the members of the SCRT officers, the diet, the CTEs, College of Teacher Education, that is the B.Ed colleges, the IASs, etc. Now, as it is, there is a positive indication from the government that these files have been processed pursuant to the Honorable Court's order. All we want is that these process which they have initiated, these should be culminated in accordance with the guidelines which has been framed and in accordance with the guidelines which has been framed by the MHRD. And why this is necessary? Because even the restructuring of the SCRT will probably not be done in accordance with the guidelines issued by the MHRD if this process which they have initiated is not taken to its logical conclusion. I'll just point out the relevant guidelines and the documents on the basis of which we say that this is the necessary process which has to be completed if the entire restructuring of the centrally sponsored scheme of teacher education, which is envisaged by the MHRD guidelines, is to be completed. Or if your lordship kindly takes up, there have been several missions, concept papers, etc. So and so. First of all, the joint review mission on teacher education, which was held in the year 2013 at page 57. We have just enclosed the relevant extracts of those documents. Page 57, Annexure 4. This is the joint review mission on teacher education, Assam. And the recommendation at page 58.
Yeah.
These missions, this was also held in connection with the restructuring of the centrally sponsored scheme. Page 58, recommendation, section 3, restructuring of SCRT. The second recommendation, if your lordship peruses, state may like to consider a common cadre for teacher educators for effective management by the SCRT. These would also create promotional avenues for all teacher educators placed in diets, CTEs, and IASCs. A minimum tenure of 3 years for the chief of SCRT needs to be ensured. The next position of director, joint director, and deputy director should be treated as academic position irrespective of cadre. I'm reading this because this has a relevancy. I'll come to this later on. Then state may also like to consider raising the status of SCRT to a higher level system, which will help in integrating all levels of TIs within the state under one umbrella, both academically and administratively. So the joint review mission, which was held in the state of Assam, it had recommended that a common cadre of teacher educators would be constituted. Now, the next relevant document at page 63, the concept paper. Concept paper, page 63.
Yeah.
This is a strengthening of State Council of Education, Research and Training, SCRT, issued in the year 2017 by the Ministry of Human Resource Development, Government of India. The relevant page at page 66, which I'd like to point out, page 66. We have just enclosed the relevant extracts of those papers. The last paragraph, clause 3.8. Separate cadre of teacher educators. There is a need of separate cadre of academic, educational, administration, and technical faculty at SCRTs and diets, without which there is a gap related to education and training. Creation of separate cadre for teacher educators is also one of the trust areas under the CSST, that is the centrally sponsored scheme on teacher education. However, 16 states have submitted in the TEAB. TEAB is the Teacher Education Advisory Board, that have separate cadre for teacher educators. that is Andhra Pradesh, Assam. So the state of Assam has already submitted before the TEAB, Teacher Education Advisory Board. They have a common cadre of teacher educators. And these processes, these publication of concept paper, joint review mission, these were all part of the restructuring process of the centrally sponsored scheme, which was confined to the SCRT in the state of Assam. In other states of India, in some states, they have carried forward both the SCRT and the diet in the restructuring process. But in the state of Assam, they have only confined the restructuring process to the SCRT, leaving out the diet. That is why these litigations have exploded. Now, so state has already represented before the TEAB that we have a common cadre. But the fact, as I had placed the speaking order shows that that file is still under process since the year 2014. And why they had processed the file? Because they could not have which they are relying on for restructuring the SCRT, that unless and until a common cadre is created, the funds would not be released. There's a clause there. So these process has been initiated, but still it has not culminated as it should have. And that is a basic grievance. I'll place that relevant clause also where it is. For that, Lordship, we'll have to take up my affidavit in reply, which we have filed. We have endorsed those document there. Affidavit in reply, we had filed on 21/12/2020.
If I may interfere for a moment, Lordship. If Lordship is taking up this matter of final disposal today, or because we have filed the affidavit.
Yes.
So a date may be fixed for final disposal, Lordship, because we are not ready for the final hearing today.
Oh, that was the understanding.
Even last, probably I had submitted. before
Then
the
Lordship
court
will hear
yesterday.
the other side. We'll give the reply immediately on after Holy, Lordship,
Let us hear it together.
together.
Much
Then a
better.
date may be fixed, otherwise it will be all wasting of time today.
When do you want?
14th of March, Lordship, if it is convenient for my beloved.
Is it okay? 14th.
Highly obliged, Lordship.
Well,
12, my lord, a BTC. RB Bora is representing BTC. But he is suffering from eye infection, my lord. But we take on the matter next week, my lord.
It's on 14th March.
Lord.
Your good name? A Bora.
6.
If it can be on 16th, your lordship.
A Bora, let us talk to the on request made on behalf of Mr. R Bora.
RB Bora, my lord.
RB Bora, London Standing Council, BTC.
BTC, my lord.
This is the matter on
16th, your lord.
Okay.
13.
Please, your lordship, for the time being, continue another court.
who's your
Engage
senior?
counsel.
Who's your senior? Who's your senior?
My lord, in this case, Mr. Yuken, I will come, but I will study, my lord, if he gets it, my lord. In the meantime, I will study facts, my lord, what is the facts there? My lord, the petitioner before your lordship is the principal as of now, my lord, he is the principal of Uttar Guwahati College, my lord. My lord, but my lord, your lordship will find page 38, my lord, whereby the petitioner was awarded PhD degree, my lord, by the Guwahati University, my lord. page 38, my lord. The after by the resolution by resolution of the my lord Executive Council resolution number 2004 222 dated 21/02/2004, my lord. I was the serial number 123 fourth, my lord, Dilip Das. Serial number 4, I was, my lord, my subject was science physics, and my lord guide were Professor Dr. Amar Jyoti Chaudhary, Department of Physics, Testo University, and Dr. G.K.D. Majumdar, my lord, Department of USC, Guwahati University. And the study was, my lord, design study of a laser-based air quality monitoring system with PC-based data acquisition system. So this was confirmed in 2004. Now, my lord, after 2004, there was no problem, my lord. Now in 2016-17, some Swarup Jyoti Bordoloi had made complaint that there is a plagiarism, my lord, in my PhD thesis. And there, my lord, I was not invited for, initially I was not given any opportunity for, my lord, hearing. A committee submitted a report, my lord, there is a plagiarism. I came to know about that from a, my lord, newspaper report. I filed a representation then that, my lord, that your lordship will find page 40, my lord, 40. 40, my lord. This is my representation, my lord, that 25/9/2018. My lord, here my representation was, my lord, prayer for providing reasonable opportunity of defending against the false, vague, and contradictory allegation leveled or imputation of academic plagiarism made against the doctoral thesis of the applicant for the ends of natural justice. My lord, I was awarded doctoral degree in 2004. In August 8, 2018, issue of Assamia Protein, however, carried a news item which claimed that the thesis I submitted to the university for my doctoral degree titled so-and-so had plagiarism contents. I have come to know these contents, my lord, only from, my lord, the newspaper report. Then I filed this representation that I may be given opportunity. Then I filed RTI also. What is the report? Give me the report. They have given the RTI. Thereafter, my lord, I have, your lordship will find page 41. This is the RTI report forwarded to me by the Deputy Registrar, my lord, Guwahati University, that in response to the above RTI application, please find here the signed copy of the report. Inquiry committee constituted to examine the PhD thesis of Dr. Ghazi Ahmed and Dr. Dilip Das, which was handed over to Mr. Swarup Jyoti Bordoloi. And who is this Swarup Jyoti Bordoloi? He is neither an academician nor a student of Guwahati University, nor any university. On the basis of this complaint of this person, my lord, they have initiated inquiry. They have found that I have been, my lord, indulged in the academic plagiarism, and, my lord, the report has been given to him, but I have no knowledge at all. My lord, your lordship will find the report at page 42, my lord. This is the report. This report was submitted, my lord. Your lordship will find page 44 is the date. This report was submitted 15/5/2017. 15/5/2017, my lord. Your lordship will find page 44, last part, my lord. I'll come to the contents of the case, my lord, but date, I'm showing the date, my lord. And this has been, my lord, informed to me only after my ITI application on 13/10/2018. And what is the contents of this, my lord, report, your lordship will find. The facts is there, my lord, the page 42, my lord. The committee constituted by the Research Council in the meeting dated 22/9/2016 is as follows. Dr. Jatin Kolita, Dean Faculty of Science, Professor Tulsiba, so-and-so, Professor so-and-so. The committee examined the complaint received from Swarup Jyoti Bordoloi on extract copy of the contents from the PhD thesis of Dr. Ghazi Ahmed and Dr. Dilip Das. The members of the committee collected the thesis and entered Professor Tulsi Barua, so-and-so. For checking similarity independently, the overall report as follows. My lord, here I'm coming, my lord, the facts, my lord. One, my lord, Ghazi Ahmed was also a research scholar during my time in the same department. we both were, my lord, the, under the guidance of Dr. my lord, Arunjyoti Chaudhary and my lord, Ahmed, this Chaudhary, my lord. Another one is, well, Dr. my lord, GDK Majumdar. We are both. The my lord, your lordship will find there was similarity. I don't say was no similarity, but my lord, there was the, my lord, we are not the expert on this issue, my lord. The PhD thesis was submitted in the my lord, council, academic council. They approved it, my lord. We both of them did the my lord, PhD in the same, my lord, under the same guidance of the same persons, my lord, and we published together numbers of my lord, the research paper. Both of us, my lord. Your lordship will find research papers there, my lord. Your lordship will find, if my lord, plagiarism is charged against me, that should be charged against Dr. This, my lord, my lord, the another person against whom G.A. Ahmed also. But no notice was given to him. My lord, your lordship will find, for the time being, my lord, I'm showing your lordship, page 66, for the time being, my lord. I'm showing this. My lord. I'm coming to other part, my lord, page 66, my lord. Page 66 in my lord, regional conferences of physics research in the Northeast. This is a prospectus. Your lordship will find page 67. This is a journal, my lord, wherein, my lord, our research articles were published. We both, my lord. This is, my lord, first name is the design consideration of application of laser-based air quality monitoring system. This is first writer is G.A. Ahmed, against whom, my lord, they are saying that I have plagiarized some contents from this, my lord, G.A. Ahmed. But the next writer was Dilip Das. It is me, my lord. We both did research. Similarly, my lord, your lordship will find next article, my lord, it is page 68, my lord. Asian Journal of Physics. Page 69 is Asian Journal of Physics. This is page 69. Who were the writer, my lord? Here, first writer was me, look, D. Das, and next writer was G. Ahmed, against whom they are claiming that I have plagiarized some articles from G. Ahmed. Why did it not brought any plagiarism against G. Ahmed? My lord, next article is, my lord, your lordship will find there are numbers of articles, my lord, where both of us were, my lord, co-writers. I don't understand the, my lord, contents, what is there inside, because I'm not an expert of physics, my lord. But, my lord, your lordship will find the writers of both. Next is, my lord, page 75, my lord. Page 75. Here is also writers are, my lord, G. Ahmed and D. Das. D. Das is me. G. Ahmed is against whom that they are saying, my lord, plagiarism. Next, my lord, there are numbers of journals, my lord. I have annexed all these journals, my lord. Where, my lord, both of us were, my lord, co-writers. The issue was, my lord, your lordship will find, lordship draw attention to page 42 against, my lord. 42, my lord. Yes. 42, my lord, the report submitted by, my lord, the thesis title of Dr. G.A. Ahmed was Design Consideration of Laser-Based Air Quality Monitoring System. Up to this, my lord, it is okay. Now, deference was, my lord, coupled to microprocessor linked data recording. And mine was, my lord, next, training of documents B, my lord. Next, right below, my lord, that training of documents B, my lord. Thesis title, next one is, that was my lord, research. Design study of laser-based air quality monitoring system. Up to this, my lord, we were similar. Now, next part is, my lord. Next part is with PC-based data acquisition system. That is the instruction given to me by my client, as well as, my lord, Professor Amarjyoti Chaudhary, who is the renowned scholar of this state of Assam, my lord. In fact, with my all respect, my lord, I will say, he's one of the best physician of, my lord, this Assam as of now. So he, my lord, he also appreciated this. He also, my lord, explained this before the committee. That no, there was similarities, but the difference is that in the first one, they studied system coupled to microprocessor linked data recording. In the next one, I researched, my lord, along with others, with PC-based data acquisition system. That was the difference. And, my lord, that was the fact.
And my lord, this report 2017 was given behind my back. I was not given any opportunity of hearing. Even no notice was issued. My lord, I came to know about only from the newspaper report. I have submitted representation. Then only I have given this, I have been given this report. Then, my lord, I have submitted my reply also. Now, my lord, there is my lord, reply. I have given my reply that was considered or not. There are again, my lord, then they have brought this, my lord, the allegation that the my lord 2018 rule come into force. They have now punished me under the 2018 rule. I'm coming to that, my lord. This plagiarism, your lordship will find that impugned, my lord, for the time being. Before that, my lord, I want to show your lordship this honorable, one of the courts of this honorable court, my lord, page 65. This was a PIL filed by that Swarup Jyoti Bordole, my lord, against my thesis, my lord. What this honorable court observed, my lord. Your lordship will find page 65. This is the order of division bench, my lord. The para 2, my lord. We have heard learned counsel for the petitioners, and we have considered the issue. We find that any order passed in the petition would be implementable. It is known to person who is committing the wrong, that is wrong. At best, it would be claimed in the person at the instance of the students who are required to study such plagiarized materials, or at the instance of the person whose work has been plagiarized. So the matter was dismissed. As the matter was dismissed, my lord, he again approached the Guwahati University. Why are you not taking action against? He approached the honorable, my lord, his chancellor, lord, my lord, the governor also. The governor directed, why are you not taking action? My lord, these all are pressurized by this Swarup Jyoti Bordole and another professor who was, my lord, in my college, who was against whom I draw a disciplinary proceeding being principal. He again filed a representation. Why no proceeding has been drawn against this person? Now, my lord, in law, my lord, they has penalized me under the rule 2018 of plagiarized petition, my lord. The lordship will find the impugned at, my lord, page 51, my lord. This is the impugned of order, my lord, whereby which has been challenged here, my lord. Page 51, my lord.
Yes.
Page 51, may I read this, my lord? It is for information all concerned then, on receipt of the complaint of alleged plagiarism of Dr. Dilip Das on the basis design of so-and-so, 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 for which he has been awarded PhD and subsequent inquiry conducted by IAIP and approval of the findings. Even in IAIP also, I was not given opportunity of hearing it. Approval for findings and recommendations, the following actions are taken in respect of the Dilip Das for proven involvement in the plagiarism as approved by the Executive Council by resolution number so-and-so. In accordance with the relevant provisions of University Grants Commission, promotion of academic integrity and prevention of plagiarism in higher educational institution regulation 2018. Under this provision of this, my lord, of this regulation, the following, my lord, the punishment has been inflicted, have been inflicted, my lord. The manuscript of the PhD thesis of Dr. Dilip Das be withdrawn for a period of 2 years. One annual increment be denied to Dr. Dilip Das, and the matter be informed to the government of Assam for necessary action. Dr. Dilip Das be not allowed to be supervisor to any master, MPhil, PhD student, scholars for a period of 2 years. The guideship of Professor the retired Amar Jyoti Chaudhary and Professor R.K.D. Chaudhary be withdrawn. My lord, I have nowhere seen in the 2018 regulation, my lord, that guideship of a person can be withdrawn by the committee. I have nowhere seen. There is no provision at all to withdraw the guideship of a, my lord, guide. Now, my lord, I want to draw your lordship the regulation, my lord. I have annexed the regulation, my lord. Regulation, your lordship will find page 55 with the notification of this regulation. Page 55 is regulation, my lord. This is but notification by the, my lord, UGC, my lord. In order to put sake on plagiarism and recommend some institutional mechanism to eliminate the scope of means in the higher education system in the country University Grants Commission in its 538th meeting held on 23/2018 considered and approved the UGC promotional regulation 2018. This regulation have been notified on the official gazette on 31st July 2018 and are available on UGC website with effect from so. You are requested to put on force this regulation in your esteemed university and affiliated colleges and ensure compliance of the same. So this has been notified on 6th of August 2018. So this has been come to force from 31st July 2018. Now, my lord, the next piece you'll also will find. This is the original regulation. That was the notification. The regulation was notified New Delhi on 23rd July 2018. And right below, my lord, 1E, right below in the same piece, page 56, my lord, it is clearly said, this regulation shall come into force from the date of their notification in the official gazette. This notification was gazetted on 23rd July 2018, my lord. So how can, under the provision of this regulation, a person who has been awarded PhD degree in 2004 can be punished? This regulation, your lordship will find, it's not a matter. This is not for giving penalty. This is for prevention, to prevent plagiarism from the date onwards. The aim and object of this regulation, page 58, my lord, is there. This is not for giving penalty. This is to prevent the plagiarism in the higher education institution. Your lordship will find, my lord, the object of this regulation. First, my lord, to create awareness. Page 58 of the description, my lord. Page 58, my lord, object. This is the object of the regulation. That is the object of the regulation, my lord. So what were the objects, my lord? To create awareness about the responsible conduct of research, thesis, desertion, promotion, academic integrity, and prevention of misconduct, including plagiarism in academic writing among students, faculty, research, and staff. So first word is, my lord, to create awareness and to prevent. This is the object, my lord.
3.3.
Yes, 3.2. My lord, that's I'm coming. My lord, that awareness has to be created first. I'm not saying no punishment should be given. Punishment should be given only after the 2018. If, my lord, there is system that you have to establish a mechanism to, my lord, to examine whether there is a plagiarism at the time of submission of the thesis. At the time of submission of the thesis, not after thereafter. If you have not established that mechanism, this mechanism is not available. In 2004, there was no mechanism. That mechanism was not there. This is established only after the regulation 2018 is enforced. So whatever punishment you inflict after, my lord, punishment, the penalty provision cannot be inflicted, my lord, retrospective effect. Which retrospective effect? It can be prospective effect. There are, my lord, I have not found this is a new rule, my lord. I have not found any, my lord, judgment of Honorable Apex Court or of this Honorable Court. But there are, my lord, judgments of other high courts, my lord, where it is said. It can be only prospective effect, not retrospective effect. So who has filed, my lord, PhD thesis in 2004, you cannot search plagiarism now. Then all the thesis, my lord, whatever they are, those has to be, my lord, again rechecked under the, my lord, system. The university authorities to do that. Each and every one, my lord, in all the research papers. To establish, my lord, the next period was to establish institutional mechanism for education and training to facilitate responsible conduct of research, thesis, desertion, promotion, academic integrity, and deterrence of plagiarism. So first 3.1 and 3.2 has said, my lord, you give the awareness, prevent all this. Then, my lord, to mechanism, institutional mechanism has to be established. Then, my lord, punishment comes. If the university authority, my lord, develops to develop the system, now, my lord, system has to be developed. To develop the system to detect plagiarism and to set up mechanism. Whether my lord, the university had set up any mechanism in 2004 when I had submitted the thesis. There is no mechanism. Whatever mechanism was there, that committee has approved me. The highest committee was that my lord academic council. They have approved my PhD after going through all the materials. So now mechanism has come to check the plagiarism. This is only established from 2018 only. This notification has come in 2018. Mechanism to prevent plagiarism and then only punish a student, faculty, researcher for staff of higher education institution committing the act of plagiarism. Then only, my lord, first of all, then university has some duty, my lord. They have to establish this mechanism. They say, if they found here, then there can be punishment. So unless it's until they establish the, my lord, mechanism before submitting or while submitting the, my lord, thesis paper, they cannot say it. Because I submitted in 2014. Then, my lord, there are duties of the higher education institutions. It is duties are there. What duties they have, my lord? Your lordship, regulation 4. They have prescribed duties, my lord. Whether they have done their duties prior to giving me the, my lord, charging me plagiarism. So from the entire reading of the entire, my lord, regulation 2018, it is clear. Even the, my lord, it is specifically said this regulation will come with effect from the, my lord, notification in the official gazette. So by no means the person who has submitted, my lord, PhD thesis, who has obtained PhD degree in 2004 can be charged plagiarism under this provision, my lord, under the provision of this regulation. And I'm not even going to the, my lord, natural justice. I have no natural justice has been followed. I have argued, my lord, I have said already. Even I'm not going to the natural justice. If, my lord, necessary, my lord, senior, you can I will argue on that point. But I have already said, my lord, before, without.
Are you arguing or he's going to argue?
No, my lord, if necessary, my lord, in that part, I'm only this part, my lord, that no punishment can be inflicted under the 2018 rules, regulation, my lord, which is in retrospective effect. This is not a prospective. My lord, I have some judgment of this other high courts, my lord, but this is a case of Andhra Pradesh High Court. Case of Andhra Pradesh High Court, my lord. The writ petition was filed to declare the, my lord, the second paragraph from my lord. Case of the petitioner is that she joined in the respondent university in the cadre of assistant professor on 30/11/1988 and was posted for college home site so post verification of the university. She opted to the state of Andhra Pradesh and joined as professor in the College of Home Science guaranteed on so. She was given charge of Dean faculty so in 9/11/2010 and discharged her duties in charge of the Dean till 24/3/2018. At that time, a full-time Dean of Home Science was appointed as process of selection. As he was not selected for the said post, he challenged the process of so and semi-spending. While things stood, thus she was issued a memo dated 10/10/2018 seeking an explanation from the petitioner and two other persons regarding alleged plagiarism. Petitioner submitted explanation by letter dated so. The University Grant Commission formulated regulation, namely University Grants Commission Promotion, Integrity of Prevention of Regulation 2018, that is, my lord, in short, regulation. The said regulations were adopted by the university by resolution so dated on 15/12/2018. However, the said policy so sought to be implemented by the respondent with effect from the academic year 2019-20 and in respect of this thesis reservation project report determination after 30/6/2019. The respondent university conducted itself in accordance with the regulation without following the due process of law even before regulation was implemented by the university and imposed punishment upon the petitioner as recommended under regulation, hence this writ petition. the respondent university filed counter affidavit stating entirely that as per the minutes of the university regulation are applicable to the student who are studying PG courses for the academic year 2019-20 and not to teaching faculty. The regulation does not prevent to take action against the teachers who were indulged plagiarism prior to the issuance of regulation in the official gazette and praise the dismissal of the writ petition. My lord, then next, my lord. The main contents of the learned counsel for the petitioner is that regulations were adopted in the university only on 15/12/2018 and sought to be implemented the policy from the academic year 2019-20 and in respect of the thesis dissertation project report submitted after 30/6/2019 and as such the respondent could not have imposed punishment on the petitioner based on which the irregularities came into effect much later than the alleged plagiarism article project work or the subject matter of the plagiarism were published way back in the year 2015-16. This is only in 15-16, my lord, this was published. Basing on the regulation, petition was imposed on so-and-so, punishment of withdrawal of the manuscript, denying two successive annual grade increments and not allowing the to be supervisor to any new PG so-and-so for a period of 3 years. This was the same similar kind. As seen from the regulation, the said regulation come into force from the date of gazetting. It is specifically said. And the respondent university adopted the same academic year from 2019-20 and the respect of their project report submitted after 30/6/2019. It is nowhere stated in the said regulation that they are retrospective and the same is not denied in the counter affidavit. It's also not denied by my lord. It is also stated that in the affidavit filed in support that writ petition that the subject matter of plagiarism was published way back in the 2015-16. Ours was published in 2000, my lord, 4. The said fact is also not disputed in the counter affidavit. This is not disputed, my lord. Learned additional advocate general appearing for the respondent university fairly considered that the regulation are prospective in nature. Its regulations are in view of the facts and circumstances of the case, the writ petition is allowed, setting aside the impugned memo dated so-and-so, no order is to cause miscellaneous petition. If any pending, the writ petition stands closed. So this is principle is that, my lord, this is prospective in nature. Another judgment, my lord, this is of Kerala High Court. The issue was here also, my lord, same. My lord, page 4 of the petition. Para 2, it is the issue was there, my lord. The petitioner submitted that he was awarded PhD degree in 2009, during which time there was no procedure prescribed under the University Act to statute or withdrawal of the degree, except in accordance with the procedure of chapter 35. However, after framing of the policy P17, that is, my lord, the regulation of this regulation, the subcommittee of the syndicate of it had called upon the petitioner to answer certain allegations. The petitioner submitted Exhibit P10 reply. The petitioner later came to know that the newspaper report that the subcommittee had filed a report, and it was at that stage the writ petition is filed. Now, my lord, your lordship may kindly see the last part, what the court has said, my lord. Para 8, my lord. Exhibit 4 University, Exhibit P17 University order is different procedure, which is now have been formulated for the purpose to conduct an inquiry of the implementing of Calicut University plagiarism check policy to prevent plagiarism, which will take from 6/4/2015. According to me, before proceeding further, my lord, the proceeding was not finalized there, my lord. Before proceeding further, the syndicate has to ensure itself whether it has jurisdiction to consider the plagiarism policy in respect of the person who had already obtained a degree prior to the Exhibit P17, that is, which was come to effect on 6/4/2015. Coming to effect, therefore, I am of the view that the writ petition can be disposed of as of that. The syndicate of the university shall consider Exhibit 417 can be implemented with reference to the person who had obtained PhD degree prior to P17 order coming into force and the effect of restriction imposed. So, my lord, it is clear, my lord, in both this, my lord, judgment of this, my lord, the Kerala High Court, Honorable High Court and Kerala High Court, it is, my lord, policy is that, my lord, the plagiarism before you search plagiarism, my lord, under the new rule, new provision, my lord, the new notification, you have to say whether you can be searched under plagiarism under the new regulation. If that is clear, first point is that, my lord, because if that is allowed, all those, my lord, publication, all those research thesis has to be checked once again. So they have said, my lord, the honorable court has said, before you're going to do it, first of all, you satisfy that you can under this regulation, because regulation has clearly, my lord, as I have already said, the regulation in para 2(3), my lord, has clearly said this regulation will come with effect from, my lord, the notification of the official gazette. So they have inflicted punishment under this regulation only. Under this regulation, they have inflicted punishment. So can it be, my lord, there is nowhere said, my lord, it will come with retrospective effect. And no penal provision can be inflicted under retrospective effect. That is a principle of law, my lord. So that is the prima facie point, my lord. If necessary, I'll argue, my lord, and may argue, my lord, in that point. If necessary, I'll
Senior going to argue again or no? Is senior going to argue again or?
my lord, he's in leg, probably he will not possible to come. So
Is he going to argue?
uh, let him argue on the point of that point.
Oh, then let him come first.
Yes, let him come.
Let him first finish.
Yes.
Sometime or you want it on a different day?
Well, he has some other matters also here, but probably I don't know whether he will get the time, because in court number 1, he is too busy today. So if your lordship permits, can it be fixed on some other date? That will take time, my lord. That is some other date.
Okay, and request me then you can hide it. When do you want?
Any date, my learned city of friend.
16th part?
Part
No, not part.
16th.
16th of March.
16th. Can it be on 9th, my lord?
You want it on 9th?
9th.
I thought board busy when you got a full. After effect, not effect.
Yes. On 9th of March.
Not after effect.
9th of March. Most.
14 and 15.
Wait, please, your lordship. The side is not there, your lordship. You can start.
Yeah.
Other side is not there, your lordship. Elementary education. I
Who is
think
the other side?
it is elementary education.
No, if they are not there, then what's the point? But this soil and a topic. None of this for the elementary. Next week. Reach the matter again on 16th of March.
Yes, number. There are two other
16.
writ petition also, your lordship. Similar matter, they can be linked, your lordship, along with WPC
Along with WPC number
527
527.
2022. 2022.
Chisti, you are appearing for the elementary education?
Yes, lordship. Yes, Lord. Yes, letter 14, 15. Lordship.
We'll change the one.
They have filed an affidavit.
Are you ready with the matter?
No, Lordship may kindly grant some time, Lordship. We couldn't go through the records, Lordship.
On request made by SMT Chishti, then the standing council elementary division released the matter on 16th March.
Yes, yes, Lordship.
Oblige.
16. 16 March. একটা বাইন্ড হয়ে দিয়ে 16.
No counsel for the petitioners.
None appears to the petition. Release the matter after 2 weeks.
Orders.
May please your lordship.
Yes, please.
Your lordship, in this matter, as per order dated 2/3/2020, your lordship.
Yes,
The notice has been served already, your lordship. So matter may be listed under admission column, your lordship. And the responding authorities is subjected to take the instruction whether I am covered by the judgment of Jivan Chandra Deka or not, your lordship.
notice is complete.
Yes, your lordship. 3/2/2023, your lordship, order dated.
But Mr.
I.H. Leskar, your lordship.
National and Council for Petition. You are appearing, Fukan?
Your lordship, I'm appearing. I'm appearing for the elementary education department.
So,
Your lordship, already private respondent has filed their affidavit, your
are you
lordship.
filing your affidavit?
Your lordship, I will be also filing that.
As
I'm
per
awaiting my instructions also.
the Standing Council Elementary Education Department. Is allow how much time?
2 weeks.
2 weeks.
Your
time
lordship,
to file counsel.
date may be fixed, your lordship.
Release the matter again on 28,
21, your lordship, March, if possible.
21st of March. In the admission of.
Oblige, your lordship.
18.
15, Lordship, here we have received our instructions and we have complied with the lordship order.
Where is the order?
Lordship, I've given a copy.
Order is at page 29, 30.
Page?
Compliance order I've given this one. Lordship, may I read it? Lordship, the honorable court had directed us to give a reasoned order, and here accordingly, Lordship, in view of the above facts and circumstances, it has been seen that the name of Jaspinara Begum has been recommended by the District Scrutiny Committee Gwalpara, and she expired before the issue of provincialization notification, but after submission of proposal of provincialization of services. Therefore, in pursuance of norms of the advertisement issued by the directorate, no fresh proposal for provincialization can be accepted after the last date as mentioned in the advertisements as per clause 2(1) of the Provincialization Act 17. The post of tutors are personal post, and after retirement and or expiry of the tutor for the post will automatically be abolished. The claim of the petitioner Azizul Islam Ahmad for provincialization of the said in place of Jasmina Begum cannot be considered, Your Lordship. Accordingly, it is.
You'll have to challenge.
He has to tell us.
But I am not getting any copy, my lord.
Yes, you'll get it.
You'll get it now.
WhatsApp पे detail.
Where is the copy?
I'll serve him a copy, madam.
Right now, the lordship is on.
You can, normally you should at least print out 3 copies and bring it.
Lordship, what happened was we have received it just a while back. Otherwise, usually we bring it, but today we've just received it just a while back. That's why Lordship, the court copy had asked the court master, requested the court master to take it out.
Who issued the order?
Lordship, it's given by the director. Director of Elementary Education.
We'll close it.
My lord.
Heard Emma Constable and Council. for the petition. By this contempt petition, petitioners alleging non-compliance of the order dated
14/3/2022. Page 29.
14/3/2022 passed by this court in WBC number 1783 of
22.
22. Mr.
A. Fukan.
A. Fukan, the standing counsel elementary education, has produced an order dated 8 September 2020 issued by the Director Elementary Education staff on perusal of the same. It appears that the respondents have complied with the directions passed by the staff. Accordingly, the contempt petition is closed. The order dated 8 September 2022 is placed on the court. You have a copy?
Emma.
Deeply obliged.
All right, back to mention one thing, my lord. I am waiting for item number 20 of supplementary list, my lord, Parhad matter. It was already called on, my lord. Sir, do we have a 10 minutes time, my lord? We need 10 minutes time to close the matter, my lord. And we have two, my lord. Only 10 minutes time required, my lord.
Yes, sir. Your senior is coming? or
Yeah,
not?
Item 10.
May I call him?
Yes.
In item 10, lordship, the petitioner has taken timing lordship in the prayer lordship, Mr. Diganta Das, senior advocate, he is appearing lordship. Time for the, my senior is appearing for Guwahati University lordship.
So nobody is appearing, I don't know. We'll fix some other day.
Lordship, I have no objection, lordship.
None appears petitioner. Mr. DJ Das, Senate Council, appeared for his phone number.
On behalf of Mr. K. N. Chaudhary, lordship, because it's Guwahati University have engaged Mr. K. N. Chaudhary.
And then council appearing on behalf of Mr. K. N. Chaudhary, standing council.
Not standing council, lordship, he has been engaged by the Guwahati University.
Senior council for the Guwahati University. Appears for responder number 2.
Lordship 2, lordship.
2 to 5. So, Mr. Matter again on. When? After 1 week?
Lordship, after 1 week, lordship, but it's a pedagogy of the petitioner, lordship. Lordship, 10, item 10. No interment, I'll work, but Kuno Naik and interment. Lordship, I've been informed that the Mr. Senior Counsel, Mr. Diganta is still in legs, lordship.
Okay. When do you want it?
So senior counsel, Mr. UK and I are on the legs before court number 1.
Oh.
So he's doing his hearing here.
Now,
After
when do
some
you-
time,
Which
after
Mr.
some
Yukna,
time,
Sometime will be difficult.
or at 2, Your Honor.
I'm told that the hearing will take some time.
Lordship, here will take some time, lordship, it's a appointment of the dismissal from service of this, it's like
Your good.
removal of service from the vice chancellor, lordship. It's
Your
a,
good name, please.
B. Chaudhary.
I heard MSP Chaudhary, then council appearing on behalf of Mr. UK Nair, then senior counsel for the petition. Also heard Mr. DJ Das, then a council appearing on behalf of Mr. KN Chaudhary, then a senior counsel for the responders 2 to 5.
2 to 5.
Please the matter after 1 week.
Lordship.
After 1. Yes, Manda.
Much obliged.
Lord,
Can it be after 2 weeks, my lord?
2 weeks, lordship.
After 2 weeks.
After
This for 2 weeks. Much obliged.
Should I complete my part?
I'm there to hear you only, I think, nothing
Yes.
more. Less.
Lord, the Lordship may kindly recollect.
1 minute.
Yes.
Oh,
Not to develop.
just a minute.
My lord.
Your file has already gone. What shall we do now?
It's for 10-15 minutes up to, if Lordship can take up.
Or it has come back.
Yes. It will be better. Well, let's come back.
Tell him, cancel the.
Yes,
Yes, proceed.
Lord, what I was submitting on the last occasion, that Lordship may recollect that the basic question is whether a panel could have been prepared, that is called select list, and whether the authority is bound to act upon the panel. And as I wanted to place before your Lordship that the panel as such was only prepared by the selection committee. Selection committee has prepared a panel of 3 selected candidates in order of merit. And the contention was raised that there is no such provision to prepare any panel even. No question of even the wait list. Contention was made that they could not have prepared a panel, only one. And I have explained how the things have worked here. The whole issue was misconstrued by the director in the sense that a panel has been forwarded to it. No panel as such was forwarded. And kindly see the situation, rules of Dudia. Here, once again, Lordship will take up the rules, 2010 rules, 496 page. 496 page. Then Lordship has gone through this method of recruitment, rule 5, 2 regarding lecturers, that is there. Then 7 we have placed, sub rule 7, and then again rule 7, sub rule A, sub rule B. We have already read that. Lordship will see regarding, I am coming to that panel, whether a select list should have been prepared or not. Because I contended that when there is a selection, the selection will ultimately culminate to a preparation of a select list. Now, here, this particular provision that there should be a select list, this is indicated at rule 17, Lordship will see. Rule 17. Rule 17. Here it is regarding seniority. Seniority, they have indicated that it should be as per the merit position. Kindly see, A, I'll just place it. Inter se seniority of employees belonging to each of the cadres shall be in order in which their names appear in the select list prepared by the selection committee. So, selection committee will prepare a select list. And in the order of their position, their seniority will be guided. That means a selection list should have to be there. And this is the normal corollary of a selection. Once selection is made, it should be, a list should be prepared. Then, kindly see, B, page 502. 502, Mukhambi. Yes, Mukhambi. I am just indicating your Lordship that select list should be prepared, and this is indicated. If 2 persons are appointed on the recommendation of the selection committee in different batches, then the person who was recommended in the earlier batch shall be senior to the person who was recommended in the later batch. To my understanding, we may conclude here that even when 2 persons were there in the position, their position will guide them whether they will be senior or junior to each other. Their position should be taken into account. Then C, if 2 or more persons are bracketed in the merit list by the selection committee, the inter se seniority of these persons shall be determined according to date of birth.
That means in the selection list, if two persons occupy the same position, they are bracketed in one group, in one position, then their date of birth will guide their senior. Therefore, my responsible submission to indicate from these rules that when there is a selection, the selection committee is bound to prepare a select list. This is the ultimate follow of the process. And in that select list, then they preferred that 3 persons out of the lot were found suitable in order of merit, 1, 2, 3. This panel was prepared and it was given to the managing governing body. Now, what the governing body did here? The governing body did not approve the entire list, that panel of 3. Governing body found that the number 1 who was placed in number 1, he has withdrawn from the race. Lordship Medical Act. That lady submitted that, no, I do not want any appointment here. Please don't offer any appointment. So that gone. 2 remained. Then second one was picked up from that list. Second one was picked up from the list, but then director said, no, he didn't submit NOC. It cannot be acted upon. He did withdraw again. He came initially before this court. Subsequently, he withdrew that, no, I do not want appointment. He has also withdrawn. His name is struck off from the panel. Then what remained? Only 1 remained. So ultimately, when 2 of them have withdrawn from the race, out of that select list, 2 of them withdrawn from the list, only 1 remains. Lordship will kindly appreciate. Only 1 remains. And that one was recommended by the governing body to the director to appoint. Now the plea that no panel could have been prepared, that is totally wrong and misconstrued. That is totally misconstrued. And as I submitted the last occasion, the governing body did not recommend 3 names at a time. They recommended only 1 out of them. They are free to do that. That is the rule that Lordship will see. In rule, sub-rule, my lord, sub-rule 7, page 198. Rule 5, sub-rule 7. In all these cases, that means regarding that appointment of head assistant, professors, principals, lower division assistant, all that is, all covering. Number 1 was for principal, number 2 was for lecturers, then number 3 was for appointment of head assistant, 4 was for post of lower upper division assistant, post of lower division assistant, 5, 6 placement of lecturers in their grade, promotional grade, 7. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. So governing body recommended 1 name. 1 name. There was not a panel of 3, even there was at the time only 2. They picked up only 1. That he also withdrew from the race. Ultimately, that 2 he also withdrew. So when 2 persons had withdrawn ultimately from the race, only 1 remained. There is no panel of 3. Only 1 remained, and that name was recommended. And the authority cannot now say that this contravenes any provision or that it contravenes the AFRBM Act. As I say, AFRBM Act is not applicable here, because there is no such thing at that particular point of time which insisted that FRBM such provision should be implemented or followed. It was not there. I will place the notifications, those are there. And no rules are framed under FRBM. This honorable court has held, the division bench has held, that FRBM cannot be brought in case of selection. This is purpose is different, because purposive construction of the act has to be done. Therefore, there is no violation even. Firstly, the FRBM Act is not applicable. Secondly, even if we strictly go by, Lordship will find that it will not go against the Section 7, Rule 7 of the FRBM Act. Because no panel was as such there. Only one name was forwarded. As I submitted last occasion, never forwarded 3 names at a time, one by one, and when 2 did withdraw, 1 remained only. There is no panel of 3 as on today on record. There is no panel of 3 as on today on record because 2 have already withdrawn. And that is why they did not ask that point when the second person filed the writ petition here before this court. And this court allowed him to withdraw and go out of the race, and then directed that now you proceed in accordance with law. What is the wrong? They never argued that it could not have been done, or the process, selection process itself was illegal. It was not there. Therefore, what I say, that even constraint for argument's sake, section 7G can be brought in for argument's sake. Here, this will also not be relevant because nothing such that a panel of 3 was before the director to act upon. That is my respectful submission. Therefore, this whole appreciation was based on some wrong premise. Director has acted on wrong premise. It was not there. And my lord, so far those notifications to keep the records clean, as I placed one before your lordship, that there was one notification which was in 20. Our case was when the selection procedure was taking place. That time, the notification was dated office memorandum regarding guidelines for selection of lecturers, assistant professors, librarians of provincialized colleges was dated 25th June 2012. That was the notification prevailing at that time. And lordship may also recollect that the director issued the letter asking the college authority to prepare a panel of 3. Yes. So in this, lordship will at the copy diva, lordship will see that here there is no such provision regarding FRBM. Nothing has been referred to. Just a glance, lordship will just give a glance. Lordship will find selection procedure for the post of assistant professor. This is the selection procedure has been laid down. Now, first, good academic record, besides fulfilling the above qualifications, the candidate must have cleared net, slate, all that, not standing anything. Lordship will see selection committee specification for assistant professor. Then that in that heading also, lordship will find nothing. Nowhere I have verified it. I have gone through it. All procedures has been marks, how to allot marks, all that is there. Last portion lordship will find. There is nothing to suggest that there is any guideline issued, because there is no rule under FRBM. Only guideline we do. Nothing was there. Here this was the office memorandum issued by the commissioner and secretary. Government. It was operating. No notification will prevail which is contrary to this. And then lordship will find there was another notification. It was issued in 8 November 2018, modifying those guidelines, guideline for selection of assistant professors, librarians, etc. This has modified slightly, that 25/6/2012 guideline. It has referred to this copy. This was in 18. Our selection was done in 17. It was done in 17. Even that 18 notification, lordship will find there is nothing, no provision at all. No provision at all. Here also, there is no reference to FRBM Act. Nothing is there. how to award marks, selection committee, who can form selection committee, how to award marks, then grade points, how to be evaluated. All those are there. Research contributions, how to be evaluated in selection, distribution of marks. That is only there. Nothing. This is also guideline for selection of assistant professors. So, Lordship will find that there was nothing that time to refer to FRBM Act. And then, my lord, last occasion I placed it, we find the notification dated 4th February 2020. 4th February 2020, that is a notification only by the Secretary to the Government of Assam. When memorandum was issued, that bears the whole weightage. Here, in this notification, I last time placed it, my lord. Lordship will find this is notification the Government of Assam in Higher Education Department is pleased to allow to give approval to the governing body of the provincialized colleges of Assam for filling up of vacant sanctioned post of assistant professors of provincialized colleges of Assam after satisfying the following terms and conditions. It doesn't lay down any procedure for selection. It only says how they should do, what they should bear in mind while discharging their duties, because the governing bodies were approved hereby. Their reference has been made, column 7, governing body of the college should ensure that the post shall be filled with strict compliance with the provisions of FRBM Act 2005, existing reservation, acts and rules, rulings and the Honorable Supreme Court, High Court, and according to the service rules and procedures established by law. That is the only requirement. And definitely here, the meaning is, my lord, they said that don't go against non-sanctioned post, because FRBM Act says those things to regulate the fiscal expenditure, fiscal part. Be strictly careful that the post is vacant, it is a sanctioned post, and only make appointment against that post. All care you must take and follow the rules and regulations which are there. Therefore, this also doesn't bring in directly the selection procedure, it should be regulated, it is not there. So, my lord, thereafter, I find another notification. It was issued in 26th November 2020. Here, this is also a guideline of 25th November 2020. Here also, Lordship will find, Lordship may find 25th November 2020. Here also, this is also selection procedure for post of assistant professor.
I've seen all this.
Yes, nothing is there. Lordship may kindly take note of. I have gone through it. There is no mention, no reference at all. All these notifications. Therefore, my respectful submission is, my lord, here, question of the violation of FRBM doesn't come. And otherwise also, as I have submitted, my lord, it doesn't get attracted in the given case, in our case. In that view of the matter, my respectful submission is that this, and the latest guideline, Lordship will find there, it is given regarding the selection procedure of assistant professors dated 24th January 2022. That is the last one. Here also nothing is there. It was 2022. Nothing is there. Therefore, here is a case where the whole process was duly followed and recommendations were duly made, and the director is bound. They cannot hold it back unless the director says that the process of selection is bad or arbitrary. And that is not the case of the director. Because here, Lordship may recollect, only to that extent, because the argument has been raised that the director is not a post office. Director has a duty to look into. My lord, what it says that rule says that the selection process shall conduct the selection process, governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. So he is bound to issue order of appointment. And There is nothing more than this.
I think I got what you want.
My lord,
I've heard you.
my lord.
Yeah.
These are only things.
That's it.
Lord, also there is nothing. And I concede to that extent even, my lord. If there is some serious irregularity or illegality in the process of selection, that can be raised and pointed out by the director. But here it was not done. They only take the point, panel could not have been there. There is no panel as such. Therefore, I leave it to your lordship's good judgment. My lord, in merciful submission, the writ petition has to be allowed and direction should be issued so that the matter doesn't get delayed anymore. That is merciful submission.
Mr. K.K. Mandal and the senior
Well,
counsel.
one small point, if honorable could permit, I am already, one point, my lord. Page 58 in my affidavit.
Mm.
This was a permission given by the director and governing body is the sole authority.
That I don't.
But one thing is that, my lord, last one line, I am not reading that, my lord, page 58 in my affidavit. In the event of candidate joining elsewhere, not offering join, the appointment authority may go in the preparing CLA list up to three, up to candidate number 3 in comparative statement and not beyond subject to approval of governing body. Next important line, my lord, I am not at that moment, last time I'm not even. This is for avoiding successive re-advertisement for the same post. Because of that, advertisement was whole cost is bearing by the governing body, not by the government. Well, so again and again, if advertisement is going on, man, we have some problem. Well, because of that, we are collecting money from the students. So
K.K. Mandal and the senior counsel.
probably approval may be given, directed to give an
Assisted
approval.
by Mr. D.K. Das. and also heard K. Guguen, and the standing counsel. Higher Education Department and Mr. N. Bora.
And Bora, my lord.
Then the counsel correspondent to info. Hearing consultant. Just one minute.
Much.
Made pleasure, Lordship.
Hmm.
I'm extremely sorry to mention
Obliging.
this hour, my lord, because I was in legs in court number 5 and that item, my lord, was for long. Item number 16, my lord. They have also taken the item number 16. Can you fix on next 16, my lord? Because my client is pressing hard, my lord. I was in legs, my junior had to run for court number 1 also. So my lord, she missed here. Item number 16.
Non-appeared for the petitioner.
Let it be on 16 March, my lord.
Heard M.S. D. Kosan. Then the counsel for petitioner.
Or 15, my
Is
lord.
the matter
Tuesday 15.
again,
No, 16.
Oh.
no?
anybody?
Purana.
14.
14 by 16. 14, yeah. That
This
will be on
matter
14.
taken on 14th March.
Oblige, my lord, deeply. I'm sorry for your inconvenience, my lord, because I was in legs for